All right. Good afternoon, everybody. Welcome to Player Maz's presentation of the new DEI Crackdown, what federal contractors must do now. You've got a full panel today of attorneys from Player Maz's various practice groups. My name is Matt Feinberg. I'm a partner and litigator in our litigation and dispute resolution practice group. I'm also the chair of our False Claims Act practice group. One of the hot button issues, obviously, is DEI and the government's attacks on DEI programs, and that is raising False Claims Act implications. And so during the webinar today, I'm going to be talking a little bit about the broader implications of DEI policies and how they can affect government contractors in terms of the Department of Justice and the federal government's current position. I'm also pleased to introduce my colleagues. First, I'll start with Sarah Nash. Sarah, you want to introduce yourself?
Hey everyone, nice to see you, hear you hopefully. I'm Sarah Nash. I'm a partner in the firm's labor and employment group. We have been fielding, as you can imagine, a lot of questions from our human resources friends and contractor friends, trying to figure out how to navigate this new EO that came out. And then we got, of course, those updates recently last week. So excited to be here, excited to talk through some of these new issues.
And Lauren Breyer, our colleague from our government contracts and claims and appeals team.
Hi, good afternoon. So I'm a partner as well within the government contracts group at Player Maza. I chair the REA's claims and appeals group, and I'm excited to talk about, the contract administration side of these issues and the enforcement implications. So thank you everyone for being here today.
Great. Thanks, Sarah. Thanks, Lauren. If we could jump ahead a couple of slides to pass the bios, that would be great. And before we go too much further, I want to go ahead and give you our little disclaimer right there. Here's a little bit of information about the firm. You can also check our website, which is www.polarmaza.com. For your edification, the information we are providing today is for informational purposes only. We are not providing legal advice, and we are not entering into an attorney-client relationship with you. The facts of your matter are specific to your business. And so what we're talking about today, we're really speaking in broad brushes, broader implications of a policy or a practice that's being implemented by the government. Your specific situation may differ for various reasons, and so our advice today may not apply to your specific situation. If, however, you do have questions about the implementation of the DEI executive orders or how they affect your business, you can reach out to us directly and we can address on a matter-by-matter basis the specifics of your situation. And our contact information will be on the slides at the end of the presentation, or you can again check us on the website. All of our contact information is there. All right, next slide. So I'm going to hand this off to Sarah to give us a little bit of an update on our agenda for today and get us started.
Thanks, Matt. So yes, today we're going to talk about, of course, this executive order that came out a few weeks ago at this point. We also have really fortunate timing in that the FAR Council just implemented additional guidance last week, and we've got FAR clauses that we can work from. So a few changes are coming out of those developments. Glad we're having an opportunity to talk about that today. Talk about a brief history of DEI with this administration. A lot of folks know that this is not the first executive order on DEI, probably not the last. So we'll go through a little bit of that history, a little bit of the fraud initiative that was issued last summer by DOJ. Additionally, of course, we're going to go through the executive order, those requirements, best practices, rules of the road, things that you as contractors need to stay ahead of as these contracts start being updated and these requirements apply to your business. We're also going to talk about navigating these threats that come out of non-compliance with the EO, making sure that you understand the full scope of how to respond if, knock on wood, anything does go sideways. And then lastly, we welcome your questions. There are a lot of folks on the line with us today, so apologies in advance if we do not have an opportunity to get to your questions. we will try to reach out and try to address everything in sort of maybe broad strokes. So let's jump into the history. If you could advance the next slide, we'll get into this. Wonderful. So last year, we first started seeing some changes in terms of government contractor requirements when it comes to DEI. A lot of folks remember that Executive Order 14173 was issued fairly early on into the Trump administration's tenure, where it revoked certain obligations that had pretty much been staples of government contracting since like the 1960s. One of those big changes was that 14173 took away obligations to create affirmative action plans for women and minorities. In addition to taking away those affirmative action obligations, they went a step further and said that any illegal DEI, including affirmative action programs for women and minority, is considered impermissible under new requirements. There was a little bit of confusion about what exactly illegal DEI meant at the time. We're still sort of trying to figure that out, but essentially the administration confirmed that it's anything that is inconsistent with non-discrimination laws, rules, and requirements. So when we're talking about Title VII obligations, when we're talking about age discrimination obligations, those general non-discrimination obligations still apply to government contractors. Slowly over the months following that executive order, we've got a little bit more clarification on do's and do nots. There was a strict requirement that any government contractors were to get rid of their affirmative action programs for women and minorities. There were also changes in a lot of the FAR regulations that addressed EEO generally. Still obligations on government contractors not to discriminate on the basis of race, gender, sex, religion. Those obligations still remain. However, on top of that, there's some additional commentary from executive orders that basically say you're also not allowed to provide certain preferences to certain groups based on their gender or their race. Important to note that certain affirmative action obligations do still remain under statutory requirements. Contractors above a certain number of employees are still obligated to have affirmative action plans for individuals with disabilities and veterans. Those obligations remain. It's just the women and minority affirmative action programs that were removed. We had a little bit of clarity issued under that prior executive order with respect to what types of actions were unlawful. Generally, it's taking any action that's motivated in whole and part by a protected characteristic. It's important to go through these because the executive order that came out in March is very different. It is a different scope of illegal DEI or impermissible DEI that we're talking about. At first, there was a little bit of confusion about what the difference is. We'll go over some of those differences, but generally, last year's executive order applied to sex and race preferences, whereas this executive order really is focused on race. It does not deal with those other protected classes at this time. Could we move to the next slide? Another requirement of Executive Order 14173 was that it obligated contracting officers to start requiring certification with certain contracts. Basically, it's a contractor certification that it is compliant with federal anti-discrimination laws, and it does not operate any programs that are promoting DEI that violate those anti-discrimination laws. Contract requirement that was pretty big change at the time. We'd never seen anything quite like that certification. It also raised questions of False Claims Act obligations. Matt is going to talk about those FCA liabilities later on in our program, but it's a really big hammer that the government can rely on if it needs to for violations of these various DEI requirements.
And before we move on, that certification that the government is requiring, particularly that is material to the government's payment decisions, it's a little bit of tragic foreshadowing. That's a really important certification that the government is trying to use to bypass some of the problematic portions of its executive order. And I'm going to talk about that in a few slides, but keep an eye out for that one.
Matt will also be talking about litigation that was recently filed. We've got a couple questions about what the litigation is. We'll touch on that as we get through the information in the program.
All right, so mid last year, the Department of Justice announced a civil rights fraud initiative, which is essentially a program designed by the Department of Justice to target DEI and anti-Semitism, and it serves overall the Trump administration's policy goals of driving diversity, equity, and inclusion out of federal government and out of the federal contracting space, particularly out of institutions of higher learning. The Civil Rights Fraud Initiative essentially made it a violation of the False Claims Act to for government contractors to engage in practices that promote diversity, equity, and inclusion in terms of hiring and promotions, and also to engage in activities that would promote anti-Semitism in the United States. One of the main reasons this civil rights fraud initiative was created was to put pressure on colleges to sort of a smaller, more niche issue, ensure that traditionally women's spaces like women's bathrooms and women's locker rooms were not available to transgender women. It was a very significant move by the Department of Justice in order to hold colleges accountable for operating inclusively to include transgender individuals as well. There are, to say the least, very serious problems with the implementation of the Civil Rights Fraud Initiative. The False Claims Act itself is designed to police fraud and material misrepresentations that are advanced to the government. And so there are a number of elements. I'm going to talk about those a little bit later. But the issues of falsity, materiality, scienter, which is the mental state you need to create a False Claims Act violation, and damages, they are all very difficult to achieve through the Civil Rights Fraud Initiative. And candidly, DOJ has had a very difficult time explaining its position about how it's going to make out a False Claims Act suit against individuals or companies that have DEI programs. I attended a conference earlier this year. I specifically asked the Department of Justice attorney who is there how they plan to enforce this, and the DOJ attorney declined to answer my question and was not willing to share any theories of liability. To me, that meant they hadn't fleshed it out. More recently, the Department of Justice has spoken publicly. One specific DOJ attorney has spoken publicly about how the government intends to prove its case, and it essentially has said, we believe a jury in a False Claims Act matter will believe our theories of liability. It's going to be a tough road for DOJ to hoe, and so we're going to talk about this in a little more detail later. But just keep an eye on the Civil Rights Fraud Initiative as it's a little bit of it's a tool to bludgeon opponents rather than to actually get liability through litigation. Another problem with the initiative is that it is circular. It targets, quote, illegal discrimination, but you can't have an FCA violation until the underlying practice is determined to be illegal. That makes compliance virtually impossible to accurately evaluate in real time. You would have to come to a conclusion that your company has acted illegally, and then you've already violated the FCA if that's the case. That's not how the FCA is intended to be drafted. There is a mental state requirement. Your actions must be knowing. So you have to know that you're acting illegally at the time you're acting illegally in order for there to be liability. It's a very difficult standard for the government to meet on these DEI claims. But also, somewhat humorously, this initiative is likely to have impacts contrary to the Department of Justice's purpose. For instance, it's expanding liability, and DOJ has doubled down on this a bit, expanding FCA liability to claims where minorities are claiming workplace discrimination creates an FCA violation. So an individual who claims that they were discriminated against, such as a woman or a person of color who indicates that they were discriminated against by a supervisor based on their protected characteristic, that would create a False Claims Act violation. That is not the purpose of this program. That's not what the Trump administration is aiming to attack. What they're aiming to attack is essentially programs that allow for minorities to gain preferential access to certain trainings and promotional opportunities, or quotas about hiring and promotions. And this ultimately could, since this is a political initiative, could end up backfiring on the administration and causing a lot of headache for them in the future. Okay, we can move to the next slide. And I'll hand it back over to Sarah to talk about EO 14398.
The star of the show. I'm sure this is why everyone's here today. It's important. Remember, we talked a little bit about the history. There are a lot of differences here and a lot of things to point out in terms of what's unique about what we're seeing. Your contracts at this point, unless you have really eager primes, should not have a lot of these requirements in them, but that will change over the next few days. We'll go over the timeline. Basically, new solicitations and contract awards will have to start having the new language in them as of, what is today, Friday, as of Friday. And then current contracts will be updated this summer. We'll go over those timelines a little bit more in depth. So what happened here? Executive order was issued, 14398 was issued March 26, 2026 of this year. Again, it prohibits a very specific type of DEI. It's racially discriminatory DEI activities. It's worth going up over what the definitions are, not only because it's important to understand, but also this is a part of the new contractual obligations. The FAR clause that was issued includes these definitions, so they're going to have to start being added into your prime contracts, subcontracts, second tier subs. First of all, what does racially discriminatory DEI activities mean? It means disparate treatment based on race or ethnicity in the recruitment, employment, contracting, program participation, or allocation or deployment of an entity's resources. This in and of itself is not particularly strange. Generally, at least in the labor and employment context, that would cover a lot of the obligations that contractors have, or companies really have, not to discriminate on the basis of race or ethnicity. One unique phrase that we do not often see is program participation. It is unclear exactly what the agency is or what the administration is getting at, but I think we do have some clues. Program participation means membership or participation in or access or admission to training, mentoring, leadership development programs, educational opportunities, clubs, associations, similar opportunities that are sponsored or established by the contractor or the subcontractor. Apologies, I generally hate reading slides, but it's important that we get these definitions straight. Matt is going to talk about the fact that there has been litigation filed. I suspect there will be more cases that are filed as well. That is questioning some of the broad scope of this. But for the time being, we sort of have to work within what we're given. Generally, this is going to apply to general employment practices. You can't, and this is not different, right? You can't discriminate against someone based on their race or ethnicity. This means that you cannot have a preference for hiring a certain race. That has not changed. You cannot have a preference for giving promotions to a certain ethnicity. No surprise there. What is a little bit different is this idea about program participation, because it questions whether contracting or contractors can continue to participate in certain awareness programs, certain maybe community service programs that prioritize a certain race or ethnicity. If I were a federal contractor looking to satisfy the requirements of these EOs, I would not provide any sort of deployment of resources that support a program that is based around race or ethnicity. I will add that a lot of nonprofits have gotten the message, have transitioned their messaging a little bit from we support communities of color or we support minorities, flipped it a little bit to we support inner city communities or we support communities that are struggling economically. So you've already started to see that just in terms of nonprofits changing the way that they're operating. But there are some additional considerations that I think this EO should, if you are a federal contractor, you should go through and make sure that you are not currently supporting programs that focus on that race or ethnicity component. Interesting that the administration has left out gender and sex for the time being. I don't know exactly why that is. Maybe they thought it would be harder to get that sort of through the courts. We kind of have to wait and see. I will add, though, that the EEOC is also currently litigating certain cases where there have been preferential programs for maybe women leadership. And so just because it's not prohibited by this executive order doesn't necessarily mean that the administration is going to be okay with gender-based preferences in similar programs. We just kind of have to see how that rolls out.
Before we jump to the next slide, I wanted to make a comment about program participation, and just for everybody's edification, we see your comments and questions. We'll get to as many as we can. Some of our slides will cover your questions. If we don't get to your question, please shoot us an email after the webinar. We will be happy to answer it. But this is a relevant question that came up. Do the program participation restrictions, would they apply to student clubs at higher education institutions? And I think the reality of the answer to that is yes. However, here's what we need to talk about. It's one thing for a law school or a graduate school or an undergraduate institution to sponsor or provide funding to an organization that is designed for the betterment of people of a racial or ethnical minority. For instance, at my law school, there's a Black Law Students Association. However, that Black Law Students Association was not restricted to Black law students. Anyone who supported their mission could join, and there were no restrictions on membership. And so, in my opinion, and obviously this has not been tested, if a program is made available or a club is made available that is still open to all members of the faculty, all students, all visitors, whatever the case may be, whatever that club applies to, then it would not, in my opinion, violate the EO. However, if you are restricting membership or restricting the benefits of membership to on the basis of race or ethnic origin, then I think you would violate the EO. And one of the problematic places or one of the issues that this EO is going to cause is that just because an organization is open in its membership to all does not mean that everybody is going to assume that it is open to all. And we could get a lot of what I would call false claims of violations of the EO, which are going to create significant funding responsibilities for institutes of higher learning or government contractors. There's going to be a lot of misinformation spread. And so it's really important that if there is a club or a program or an association, that the fact that that organization is open to all is really important for that to be a like something that you're advertising. This is the Black Law Students Association, open to everyone. So that there is no question that the club is in compliance with the EO. But Sarah, jump in if you disagree with anything.
I agree. The only thing I will add is that we kind of learned this in the last EO. There are some overzealous COs out there, government officials, who don't quite understand the limits of where executive orders start and stop. And we experienced this last year with the prior DEI executive order, where a lot of things that were not illegal DEI were getting swept up into the conversation that shouldn't have been there. And so there is potential for either contracting officers misunderstanding and canceling or terminating a contract based on that misunderstanding, which obviously is a headache in and of itself. There's also incidences of the government using AI to search websites without necessarily again, being able to find the nuances of what's permissible and what's not permissible. So that's just, unfortunately, we're dealing with a little bit of uncertainty, but I agree 100% with Matt's read, which is that affinity groups are still permissible as long as they are equally accessible and it's clear that everyone is free to join, and you're not providing certain preferences to individuals based on that, their race or ethnicity in those organizations. Let's jump to the next slide and get into a little bit of the meat of the requirements in the new clause that was just issued. There are some unique aspects that are worth flagging, and apologies, this is another example of a slide that just has a lot of words on it, but I'm going to try to break down sort of the most interesting pieces of this. And then on the next slide, we'll also talk about a little bit about the FAR Council's guidance and what we learned last week and I think it was Monday about some of the language that is being rolled out. First of all, one of the obligations of this EO is that prime contractors have an obligation to flow down the requirements of the clause down to their subcontractors. Those subcontractors, in turn, have an obligation to flow it down to second-tier subs. There are a couple of narrow exceptions for contracts below the micro purchase threshold and for contracts performed outside of the United States. But otherwise, this is a very broad applying requirement. It will be or needs to be incorporated into all contracts by July 24th, according to the requirements in the EO. Those requirements, again, apply to racially discriminatory DEI, basically a blanket prohibition on any type of racially discriminatory DEI activities. We've received some questions over the last few weeks. Does this only apply to racially discriminatory DEI activities on the contract? No, it could be anywhere within the organization. You as a government contractor may not engage in racially discriminatory DEI activities, period, under this executive order. There are also some unique sort of obligations that apply to contractors flowing out of these requirements. One obligation is a information obligation. And there's an obligation to furnish all information and reports, including access to records, to the contracting agency. That basically just means, like, historically, government is not interested in your handbooks. Not a lot of incidents, that at least that I'm aware of, where the government says, let me see a copy of your handbook. Often they want to see maybe code of ethics, other obligations. This has the potential to change that. In the future, probably more requests for company handbooks, policies, different programs that you offer your employees. Just keep that in mind. Good opportunity now to take a look through those handbooks. If you didn't already give them a good scrub after last year's executive order, make sure that there's not language in there that may end up in hot water should your CO or the government ask for a copy. Similarly, you're going to have to be requiring your subcontractors to provide this information. Just something to consider as you guys are working through your contract modifications. There's also a really broad termination right. Basically, if a contractor or a subcontractor is not complying with the requirements of this clause, the contract can be terminated in whole or in part. That means that if your subcontractor messes up and has a racially discriminatory DEI program, your prime contract can be terminated. This means it's really important not only that you are flowing down these requirements to subcontractors, but also that you are monitoring your subcontractors for compliance to ensure that you don't end up on the wrong side of a contract termination decision. We don't know how this is going to be rolled out. We don't know how closely contracting officers are going to be scrutinizing these requirements, but there are certain obligations on the government to sort of give an update on their progress. And so I would not be surprised if folks started hearing about some of these questions. There's also an obligation on prime contractors to report any subcontractors' known or reasonably knowable conduct. I do not know what reasonably knowable means. It is not a standard phrase that we come across, or at least that I come across in labor and employment world. That means that I am taking it very seriously. And a little bit more seriously than other language you might typically see. I've seen reasonable belief. I've seen reason to know. Reasonably knowable is a little bit more indefinite. I suspect it's one of the reasons that's maybe the EO has been challenged in court. Matt, you can fill me in there if I'm wrong, but that's a very vague statement. What does it mean? It means that contractors have a little bit more obligation to review their subcontractor policies and procedures. Do you have to ask for their handbooks? Maybe no, maybe not. Do you have to ask them to certify that they are in compliance? Maybe. Just some additional, maybe best practices that we'll talk about later on in this hour. That's probably a good idea given this heightened standard. There's also kind of a quirky obligation to inform the contracting department if a subcontractor sues the contractor and in any way brings it issue the validity of this clause. I suspect that's a way just for the agency and the administration to keep tabs on what potential legal challenges there might be out there, knowing that they might need to get involved in the fight as well. And then lastly, there is an obligation basically for the contractor to recognize that the requirements of this clause are material to the government's payments decision. That's a hat tip to the FCA, those materiality considerations of receiving payment based on assumptions under the False Claims Act. The only thing I will add in this scope is it's interesting because the executive order itself kind of laid out exactly what the clause should say. However, as we saw in the FAR Council's guidance that was issued last week, they've incorporated those definitions of racially discriminatory DEI and program participation into the clause. So any of your clauses that are flowed down to your subcontractors will need to include those definitions as well. You go to the next slide. I said we would go through the timeline. I think I've already mentioned it a couple times, but it's worth repeating. Based on this FAR Council guidance that was issued last week, we have a little bit more clarity into deadlines now. As of Friday, all agencies should be implementing FAR 52222-90, which is the new FAR clause that applies to new contracts and solicitations. That's going to be in there. That means that any subcontracts you have flowing out of those obligations will similarly need to have that language. It's important that you are reading your contracts, making sure that you've got those obligations in there. For any current contracts, you have a little bit more time. Agencies have been given until July 24th to update current contract obligations. I'm going to tell you what we've been telling others. If you are a prime contractor, I would not wait until the day that you get that modification from your contracting officer. I would get ahead of this, communicate with your subcontractors, make sure that they're aware of the obligations, make sure that they do not have racially discriminatory DEI programs in place, and make sure that they are ready to sign on to the modification language if and when it comes. What you don't want is a situation where you're getting pressure from your CO to sign a bilateral modification, but you haven't been able to confirm with your subcontractors that they are compliant. You don't want to be on the wrong side of a DOJ investigation or a contract termination, as Matt and Lauren will both talk about. The only thing I'll add is that there are some exceptions. Contracting officers have discretion whether they decide to incorporate this clause into contracts that expire on or before December 31st. I think it's going to be a mixed bag. We'll see whether they just do. It's probably easier just to apply it across the board rather than figuring out where the timing is, but I guess we'll see some potential differences there. And again, I'll just remind folks that this does not apply to contracts below $15,000 to the extent there are those out there, and then it doesn't apply outside the United States.
So before we jump to the next slide, I do want to answer a couple of questions here. So we've gotten several that are along the lines of, do federal contractors need to wait until the federal government modifies their prime contract before they flow it down to subcontracts? So just as Sarah's answered that question, but here's the practical solution for you. You can likely modify your subcontracts, whether this executive order is stayed by a litigation, whether the modification comes late or the government decides for whatever reason not to issue a modification in a timely manner. The government makes mistakes too. They might overlook your contract. They might elect not to modify a contract that ends before December 31, 2026. But nothing prevents you from implementing these obligations to your subcontractors anyway. And you may have provisions of your subcontract that say there can't be a modification without mutual assent. Obviously, you would need to reach mutual agreement with those subcontractors to make those changes. But you don't need to wait until the government modifies the contract to flow these obligations down to your subcontractors. The subcontractor should also know that these obligations are coming, and they should be willing to work with you to make sure that you have a seamless transition. So you don't have to wait. You can wait, but that increases your risk because it can take longer to modify, and you might get some pushback. And then you're running into the problem of, well, do I need to terminate this subcontract? Is this a certification I can't make to the government because I couldn't get my subcontractor to agree? So our strong recommendation is start working now so that you can implement these. You should assume, one, that they're going to be implemented, and two, that you need to be able to implement them quickly. So you might as well prepare on the early side and make sure that you're ready to go as soon as possible after your contracts are modified. I think we can jump to the next slide. Yeah. So I guess a little bit of breaking news. A lawsuit was filed actually Monday evening, but technically not docketed until Tuesday morning in Maryland federal court, challenging the constitutionality of the EO. The plaintiffs are claiming that it violates their free speech and freedom of association rights that are inherent in the Constitution, and that it also constitutes ultra vires action by the president. What that means, ultra vires, means that it's outside the president's authority. Essentially, when the president is implementing executive orders, they're required to either stem from an act of Congress or the Constitution itself. The argument is that these DEI prohibitions do not exist within the Constitution and have not been passed through an act of Congress. So the lawsuit has been filed, it's been docketed, it's been assigned to a judge. Although it seeks preliminary and permanent injunction prohibiting the implementation of the EO by federal agencies, no motion has been filed to actually enjoin the implementation of the executive order. So just because you're asking for an injunction in a complaint does not actually mean you're ever going to get it. What that means is that if you file a motion for a preliminary injunction or temporary restraining order, you have to argue it for the judge. The judge will make a decision about whether you are likely to succeed on the merits, among a number of other options or elements, and then it will issue an order. Only if the judge issues an order enjoining the implementation of the EO will it not go into effect. And so we don't know what's going to happen with the litigation. I assume that a motion for preliminary injunction is going to be filed soon. It will likely be decided within 2 to 3 weeks. They could seek a motion for a temporary restraining order, which would normally be decided within 5 or 6 days. Here's the thing. It's filed in Maryland. The judges of the Maryland federal courts were sued by the Trump administration I believe last year, for overturning a lot of the Trump administration's executive orders and policy and political positions. So if you're going to file a federal court challenging an EO, Maryland is one of the places to do it. That doesn't necessarily mean that the judges are going to grant an injunction here. There is a similar lawsuit filed against a different executive order earlier in the late last year, and it was denied by a Maryland judge. So there are no guarantees, but this is breaking news. We're going to find out probably sometime within the next week or two whether there's going to be a decision enjoining implementation of the executive order. I'm sure that's going to be appealed very quickly. So keep an eye on our website. We'll be writing blogs and client alerts about how the litigation is moving forward, but for now, you should assume that the executive order is going to be implemented on the exact timeline that Sarah discussed earlier. And until a court enjoins it, it's going to continue to proceed. You should also assume that no matter what happens, the Trump administration is going to do everything it can to implement this EO and its anti-DEI policies as broadly and as aggressively as possible, whether it is through this executive order or through some other action by an agency or by the Trump administration. So don't put too much weight in a court enjoining the implementation of this EO, although it is certainly a questionable executive order and may well be blocked by a federal court at some time. We shouldn't assume that's going to happen. Okay, I think we can jump to the next slide.
While we jump to that slide, there have been a lot of questions, and we appreciate that there's a lot of confusion around this. Some of them are unfortunate we don't have answers to. Some of them we do. One keen individual who was paying attention noticed that the EO and the FAR guidance has some differing dates. There was initially a requirement within 30 days for agencies to update their contracts. That 30 days would have hit April 25th. However, the FAR Council sort of flipped it on its head a little bit and gave a little bit more time. That's, I guess, good news that contracting agencies have until July 25th. That was a little bit of a change from the executive order initially. Also, it seems like the FAR Council just got things together really quickly. And so that April 24th deadline is one day earlier than the initial 25th for new contracts. Because I'm a labor and employment nerd, I thought this was a good opportunity to remind folks of all of the different non-discrimination laws out there. Last year, when the executive orders came out around DEI, a lot of questions from contractors saying, great, this means we should get rid of our EEO policies, right? No, it is more important now, more important than ever, that you have strong EEO policies in place in order to justify the fact that you are a equal employment opportunity employer. You do not discriminate on the basis of race. We've been starting to see a lot of plaintiffs' attorneys pick up on the fact that they have a new angle now. They have an FCA angle that they can come after contractors with, and they're starting to use it. That means it's even more important that you've got strong, not just non-discrimination policies, but other policies that can support having a workplace free of discrimination, harassment, all of the things that on its face this EO is intended to prevent. I will also add that, of course, nothing's ever really easy, right, or straightforward. There's a lot of state obligations out there, depending on the industry, that require AAPs for certain women and minorities, depending on the industry. There is no clear answer about how the state requirements are going to play with the government prohibition. We were hoping last year we would get some clarity. All we really got was some fights that are still ongoing between the Trump administration and those state requirements. And so still jury's out. I think there are some clever legal arguments for why one or the other should prevail. Sometimes you can thread the needle a little bit and get through on some of the technicalities in the law, but there's no one size fits all, one answer. Yes, you don't have to comply with this, or no, don't worry about it. Unfortunately, we can't offer too much clarity there. This brings us to our next slide, where we talk about, and I apologize, there's a lot of information that's been shared. There's a lot going on in this world, but our hope is that we can give you some strategies for how you deal with it, best practices for how to stay ahead of it. And hopefully you can walk away from this presentation thinking, okay, I don't quite understand what's going on with this EO. No one does. But what I do know is what I need to do going forward.
Yeah. Sarah, can I ask you a question real quick?
Please.
So we have some representatives of tribally owned organizations on the call. They're asking what to do about tribal preference opportunities for hiring employees or for other tribally owned businesses. I know you and I have been talking about this. So what do you think? Do tribal preference programs for employment and promotion, are they affected by this EO?
They should not be. Again, there's always room for confusion and misunderstanding of the law. However, generally, there's Supreme Court cases out there that have confirmed that tribal preferences, it's not really a race or an ethnicity preference. It is a political preference. And that was the answer that came out of last year's EO. That's the answer that I would assume would come out of this EO. I would not be surprised if there was some additional guidance that's kind of generated over the next few weeks that confirms that 100%. Yeah, if you are a tribally owned entity or ANC, you should not have to worry about those preferences under this EO in particular.
Thanks. I agree.
Excellent.
100%.
I love when we get to the right answer or the same answer. Okay, so immediate action. Again, I would not wait until you get a bilateral modification from your contracting officer to talk to your subcontractors about this. You want to have those conversations now to the extent that you guys can agree on a modification to your contract. Great, get that in place. Make sure, as a prime contractor, I would be looking at your subcontractors' websites, making sure you don't see anything that triggers a potential racially discriminatory EEI allegation. There's also some responsibilities that you have as a prime contractor to make sure that you are policing your subcontractors. You want to make sure you've got good language in your subcontract, and you want to make sure that you are taking a little bit closer look at those subcontractor policies. We had one question that was a good question, sort of asking, like, I can't get into the details of all of my subcontractors' relationship with their employees because I'm going to become a joint employer. In practice, I generally tend to agree. However, here, because of this contractual obligation and because of the new risks to a prime contractor, you have a good reason for why you need to be in on those weeds. And I would be more worried about non-compliance from the government contracting perspective than I would about this idea of a joint employer. It's just something, just like I don't know if we've got any SCA contractors, Service Contract Act contractors on the line, or Davis-Bacon, but just like with those prevailing wage obligations, you need to be in the weeds with your subcontractors on these issues because their non-compliance, congratulations, it's now your non-compliance. There's also some things you can do to mitigate the risk of liability by vetting your policies. There's a laundry list of different policies that might relate to discriminatory racially DEI. Look at those, make sure you don't have any of the buzzwords. If I were a government contractor, I probably would stay away from the phrase DEI. It is kind of a bad word under the current administration. I will add, DEI in and of itself is not illegal. It is not prohibited by any of the executive orders, but it's not a word that right now the administration likes to see. Also, good opportunity to make a plug about the importance of having a good complaint policy. You want to make sure that you have clear policies and procedures for how to report discrimination, harassment, all that. And I think that covers up. I want to make sure that we get to the rest of our slides, so I'll stop there.
Thanks, Sarah. I think we can go to the next slide. So we have about 10 minutes. I am going to move extremely quickly on these topics. They each could be their own slideshow. So if anybody has any questions, please feel free to reach out. I'm going to be going through these rather quickly. So during the, in 2025 with the prior DEI EO, we saw a lot of our clients get swept up in adverse actions being taken against their contracts on the contract administration side, whether legitimate or not. And the first thing that came out of that review was really these stop work suspension orders were being assessed. And so the first thing you want to take a look at is, does your contract have 52.242-15? And I'm going to cover these other three items quickly too, but we can move to the next slide, just in interest of time. So take a look at your contract, see if 52.242-15 is in there. So what is likely going to happen is if your contract is under investigation or being looked at closely, they may issue a stop work notice. The stop work is going to be in place for 90 days, and that's going to give the agency a chance to kind of evaluate what policies you have in place. The one thing that you are allowed to do if a stop work order is issued is seek an adjustment for cost and time associated with the stop work period that's put into place. So that stop work can be lifted at 30 days, 60 days, 90 days. If it's at 90 days and the stop work hasn't been lifted, what likely is going to happen is a termination for default is going to be executed or a termination for convenience. If it is lifted, again, you can seek equitable adjustment through your contracting officer, and you have 30 days to seek that form of adjustment. That can be in any format, just making sure that your costs are supported and that you are mitigating the costs associated with the stop work. So if the stop work gets issued, you're making sure that you're not keeping people on the bench, you're finding projects for them and executing mitigation strategies during that time frame. If the stop work is not lifted, we can talk about terminations next. So we can move to that next slide. So one other outcome is a termination for default. So what happens is, based off of your non-compliance, the government's going to issue a notice of default. And that means you're basically in breach of contract. And what happens is, you obviously have to stop work. It gets marked on your SAM registration. It goes into your CPARs as well. And it's considered a government claim against your contract. So at that point, when you are issued a termination for default, you are actually in active litigation with the government if you want to challenge that decision. Given that there's active litigation over the validity of this EO, this is something to be mindful of, that if you are issued a termination for default, that we're encouraging clients to obviously challenge that decision, because what the contracting officer needs to justify that decision to default is they have to be substantially justified in that determination. So if there's active litigation simultaneous to this adverse action being taken against your contract, it's really important that you reserve your rights and make sure that you appeal the termination for default. And where you appeal that decision is either at the Board of Contract Appeals, the Armed Services for DoD contracts, Civilian Board for civilian agency contracts, or you can appeal that determination to the Court of Federal Claims. You have 90 days to appeal to the Board of Contract Appeals, and you have 1 year from the date of the termination to file at COFC. But once you choose a form, you are stuck there. So understanding the differences between the forms is important. We can go to the next slide. So one of the things that we are seeing under the prior DEI EO is that a lot of contractors are getting terminated for convenience. So using that clause in that contract, the government's basically saying it's in their best interest to terminate you and walk away from the contract. Some of these terminations were resolved through a no-cost walkaway, where both parties, again, walk away. There's no negative mark against your contract or your registration in SAM. And what you are actually capable of doing if you don't agree to a no-cost settlement is you can submit a proposal for costs associated with the termination. So that there's really 2 buckets of costs that you can seek an adjustment for from the government. It's unpaid performance costs and then costs resulting from that termination. That proposal typically needs to be submitted within a year of the termination for convenience being issued. And we can go to the next slide. So another potential outcome on the contract administration side is a suspension and debarment. So federal contracts can only be awarded to responsible prospective contractors under FAR subpart 9.4. And again, it suggests you take a look at that. But under that subpart, agencies can take adverse actions against you in the suspension and debarment process. These rules also apply to non-procurement transactions like grants, cooperative agreements, loans, et cetera. So it is important to understand 9.4 and the adverse actions that can be taken. And this has a more broad application. It's not just specific to a contract. It's generally applied to you as a contractor. So if you are notified by a suspension and debarment official that you are up for suspension and potential debarment, that applies to your company and entity as a whole, or potentially you as an individual from contracting in the future with the federal government. So it's extremely important that if you do get some notice of suspension or review for debarment, that you engage counsel right away, because you do have to respond typically within 30 days. You can seek a reasonable extension of that, but you basically have to address certain instances that they've flagged for why you are up for suspension or potential debarment. We can go to the next slide. So can you challenge these actions? Like I said before, if you receive a termination for default while there's simultaneous litigation over the validity of this EO, absolutely consider challenging these adverse actions, whether it's the stop work, if it's a termination for default, or even a termination for convenience, because you could be entitled to a retraction of the decision to stop work or to terminate and you could be potentially entitled to not just, lost costs, but also lost opportunity costs. So it's absolutely worthwhile keeping an eye on the active litigation and making sure that you are reserving your rights to challenge these decisions made against you. For suspension and debarment actions, that process is a little bit separate. It's not under the Contracts Disputes Act, so you need to understand your appeal rights there, and those get directly challenged with the SDO. So understanding that process is important. I want to be mindful of Matt's time talking about FCA, so I'm going to kick it back over to him.
All right, we can go to the next slide. And again, I know we're throwing a lot of information at you at a very short period of time, and we could probably do 4 webinars to cover some of this stuff. So we will be doing another webinar specifically on the False Claims Act and DEI. But broadly, the EEOs and the Civil Rights Fraud Initiative invoke the FCA. The FCA is the government's primary vehicle for recovering money from contractors or from individuals who receive government funding. And under the FCA, the government may recover treble damages and penalties from a contractor who knowingly submits a false claim or a false statement associated with a false claim that is ultimately material to the government's decision to pay. When we talk about a False Claims Act violation, it has generally 4 elements, although there are some that are adjustable depending on the type of claim that's being filed. But generally, an individual or an entity is presenting a false claim or a false statement to the government. A false claim would be an invoice that is false. It's for the wrong amount, or there is a certification, an express certification in your invoice where you are stating, you're certifying to something that is not accurate. The false statement to the government that is associated with a claim could be either an express or an implied statement. So when we talk about implied statements, every submission to the government is generally implied to represent that the contractor is compliant with applicable statutes, regulations, and contract requirements. The important parts of the False Claims Act is that there is a mental state. So if you've ever seen Legally Blonde, Reese Witherspoon stands up and starts answering what a mens rea is. We have that in the False Claims Act, and here that the contractor has to act knowingly. And that has 3 meanings. Actual knowledge means you know that you're misrepresenting yourself to the government. Reckless disregard, which means that you are making a representation to the government that there's a substantial risk. You essentially have a good reason to believe that your statement may be incorrect. Or deliberate ignorance. Deliberate ignorance is sometimes what we call the ostrich principle. It's when you stick your head in the sand while a bunch of fraud is going on around you, and you try to have plausible deniability by saying, oh, it must have been somebody else. Also importantly, that false claim or false statement must be material to the government's decision to pay. This is where a lot of False Claims Act liability falls and ultimately fails. Because candidly, for those of you who have been in government contracting a long time, for the vast majority of your career, the government, the contracting officer does not care what you do with your employees. They don't care who your employees are, what race, what gender, what ethnicity, who they're married to, where they live. They don't care about any of that. In fact, you probably have emails where the contracting officer has said, I don't care what you do with your employees, just make sure they're doing their job and you're getting me the final product that we have bargained for, essentially the services or the product. And so the government knows that this is a difficult argument for them to make on the DEI side, because we have decades of the government not caring about who is doing the work so long as the work is getting done. And so that's why we have these certifications that are in the EO and that are in the Revolutionary FAR overhaul. They're requiring you to certify that your DEI programs or your anti-DEI programs are material to the government's ability to pay, because otherwise the government may not be able to prove it. The last element of an FCA violation is that the government suffered damages. If we could go to the next slide. When I say government suffered damages, it's tied to the theory of liability. And for these DEI programs, they're ultimately making arguments that the government never would have paid any of the invoices on your contract if not for your certification that you're in compliance with the EO and that you are engaged in illegal discrimination. So what they're going to do is say that the entire contract value, the revenues, not the profits, the revenues are recoverable, and that's multiplied by 3. So if you have a $10 million contract and they say that you violated your DEI responsibilities, they're going to seek $30 million in damages plus penalties per violation. So if you have a 5-year contract worth $10 million, you've submitted 60 invoices, that's a $30 million in damages plus an additional 60 times about $28,000 as penalties. Plus, if there's a whistleblower involved, you have to pay their attorney's fees too. As I've mentioned, there's some major hurdles here: falsity, that mental state, materiality, and damages. And so these are huge hurdles for the government. But we have a recent example, a lawsuit or a settlement rather by IBM, which was announced, I believe, a week or so ago, maybe a little longer, where they agreed to pay $17 million to the government for utilizing what the government alleged was an illegal DEI program that allowed for preference-based hiring, quotas, and promotion, and people were paid bonuses based on their satisfaction of those quotas. And I'm here to say, as a False Claims Act defense lawyer, companies should fight. Do not cave. Don't be IBM. Don't pay the $17 million settlement. Hold the government to their obligation to prove their FCA liability, prove your FCA liability, because it's going to be an incredibly difficult FCA case for the government to make. And I guarantee you that the defense costs will be lower than the settlement amount at the end of the day. Ultimately, that doesn't mean start discriminating. That doesn't mean violate your EEO obligations or Title VII. All of the things that Sarah said earlier about the importance of compliance with employment laws, they remain important. But that doesn't mean there's an FCA violation if you violate them. There's a reason Title VII exists and that employees can sue. But if you fight on the FCA side, you're more likely to have the EO go away, or for the False Claims Act liability to go away, and DOJ won't pursue it. Next slide. We have a lot of questions that we did not get to. We're going to try our best to respond if there's something that you've raised. We just shoved a lot of information into 64 minutes. We thank you very much for your attendance, for listening to us. Feel free to reach out to us, any of the 3 of us, with additional questions. You can reach out to all 3 of us. Our contact information is on the screen. You can also access us at polaramaza.com. We got to make the domain name as difficult as possible to spell, but it's right there on the screen. We are going to make the recording available, so a re-recording essentially, to everyone who registered for the webinar. We will not be providing the slides. So feel free to go to that link, watch us again. Candidly, don't tell everyone I'm telling you this, but take screenshots if you see a slide that's really important to you. And we do appreciate you listening, and we'd be happy to answer any questions that you have. Just feel free to reach out to us. Lauren, Sarah, it's always a pleasure to do a webinar with you. Thanks for joining me.
Of course.
And thanks, everyone. It's been a pleasure, and stay tuned for more webinars on DEI and how you can protect your business.
Thank you, everyone.
Bye.